Remember when we distinguish between common law and equity? In today's legal method series, we'll be discussing other sources of Nigerian law. But for you to get a holistic understanding, you need to watch to the end, share the video, and leave a like as well. Common law, Doctrines of Equity, Statutes of General Application that were enforced at the first day of January 1900, all fall under the umbrella term called Received English Law. This is a major source of Nigerian law. Recall that Britain were the colonial masters of Nigeria. So invariably, most of Nigerian law were imitation of British laws. The next source of Nigerian law is Nigerian legislation. So after Nigeria became independent, then Nigerian lawmakers went ahead to make laws for Nigeria. This can be seen from the ground norm, which is the Constitution, and other legislative acts of the National Assembly. Legislations could be acts or decrees when it has to do with the federal government, laws and edicts when it has to do with the state government, then bylaws if it has to do with the local government. Under here, we also have delegated legislations. So this means where power is being given to government ministries or departments or offices in order for them to make laws guarding such offices. The laws made by these departments is called subsidiary legislations. I need to make mention of the fact that these offices are not allowed to perform or exceed the power granted to them. So this is gotten from the Latin term derivativa potesta, non potest, es major primitiva, meaning that the power derived cannot be greater than that which is derived from. Another source is the Nigerian case law. So this is where the judiciary comes in. All judicial decisions are a very important source of Nigerian laws, especially decisions of higher courts of records. That is, decisions that has precedential value. Remember that the judges don't make laws in the sense that the legislatures make the laws. Another source of Nigerian legislation is customary laws. Before the advent of the British, Nigerians had laws that govern them, and these laws are found in the customs of the people. The court in Oyewumi and Oguneso define customary law as the organic or the living law of the indigenous people of Nigeria, regulating their lives and transactions. In Ako and Aneko, the court defined customary law to mean the unrecorded tradition and history of the people, which has grown with the growth of the people to stability that it has become an intrinsic part of their culture. I need to make mention of the fact that it is still a controversy whether or not customary laws should be codified. Another source of Nigerian legislation is Islamic laws. This is majorly seen in the northern part of Nigeria, aside the existence of the Penal Code, which regulates the lives of the northerners. The sources of Islamic law include the Quran, which is the principal source of Islamic law, the Sunnah, which contains the actions, the deeds, and the precepts of the Holy Prophet Muhammad, Ijma, which is the consensus of Islamic jurists. So this comes in where the Quran and the Sunnah doesn't provide for certain actions. Then Qiyas, which has to do with analogical reasonings and deductions. So this also comes in where the Quran and the Sunnah are silent about a particular issue. So that's that for the sources of Nigerian law. If you have any questions, do well to ask me in the comment section and I'll do my best to provide an answer. If you found this video helpful, remember to share, leave a like as well. Thank you for engaging in the next legal space.